For the next speaker for the day, we have Ms. Hauwa K. Usman. It's a privilege to welcome you, ma'am. She's a Registrar General of Nigerian Chambers of Commerce Dispute Resolution Center and General Counsel to the Abuja Chamber of Commerce and Industry. With over 15 years of experience in litigation, ADR, corporate law, and legal advisory, she is a highly respected voice in Nigeria's legal and dispute resolution landscape. Ms. Hauwa is a fellow of several prestigious institutions, including the Chartered Institute of Arbitrators UK and the Chartered Institute of Mediators and Conciliators Nigeria. Her dedication to access to justice, mentorship, and community empowerment through legal education and advocacy is truly inspiring. We invite you, ma'am, to share your insights on the area landscape in Nigeria and to contribute to today's dialogue. The floor is yours, ma'am.
Thank you very much for having me. Can I confirm that you can hear me very well?
Yes, ma'am, you're audible.
All right. Good morning, good afternoon, and good evening to everyone, depending on where you're joining from. It is my honor to be part of this gathering today and to thank the Global South ADR THIRUNAAL. I was also taken emotionally by what Mr. Sharukumar was saying earlier about institutional arbitration and the importance of recognizing it within a country's arbitration landscape. And I thank the organizers for the invitation and for creating this important platform for voices from the Global South to shape the future of international arbitration. As I have already been told, my remarks will explore Nigeria's positioning as a key stakeholder in international arbitration, highlighting both public and private sector engagement, recent development and notable decisions that have shaped the arbitration landscape in Nigeria. As you are aware, Nigeria is Africa's largest economy and a major hub for international commercial arbitration, foreign direct investment, and cross-border projects, especially in the areas of energy, infrastructure, and telecoms. Consequently, disputes of international character are just inevitable within the Nigerian landscape. And over the years, both the public and private Nigerian parties have emerged as active users of international arbitration. Nigeria has never been a passive respondent in any arbitration proceeding that it is involved. And the trend is that I will now, can you move forward in my slides? I think you could go to the, thank you. Yes. So I would like to share Nigerians, both the government and the private sector involvement within the international arbitration landscape. And, you know, as I have given the background, Nigeria is a major player. And that has made, and this has been possible through Nigerian government increasingly use of arbitration clauses in contracts involving major project infrastructures, the private public partnerships, bilateral investment treaties that have been the result of some of the recent international arbitrations that Nigeria have been involved recently. And these also agencies like the Nigerian National Petroleum Corporation, which is the major stakeholder in the oil and gas industry in Nigeria, the Ministry of Finance and other state entities have frequently been parties to high-value arbitrations in international arena. Often, these arbitrations are seated either mostly abroad and governed by international rules. The Federal Ministry of Justice too in Nigeria have recently promoted a lot of policy initiatives to enhance arbitration use in Nigeria. Creation of specialized arbitration units within government organizations. So recently we have organizations like the NDIC, the Nigerian Deposit Insurance Corporation, the Nigerian Upstream Regulatory Commission, emphasizing the use of ADR and creating specialized ADR units within their organization to promote arbitration, mediation, and negotiation, as the case may be. Also, in terms of the private sectors, a lot of organizations and companies, you can move to the next, please, the next. Yes, so I'll talk about the private sector, which has also been major actors through their use, increasingly use of arbitration to resolve disputes across borders, especially under, you see them use the arbitration rules under the ICC, the London Court of International Arbitration, and also the UNCITRAL and ICSID and other regional arbitration institutions. State entities I have already mentioned, like the National Petroleum Corporation, banks, telecommunication companies, and lots of other companies in the oil and gas industry have routinely opted for arbitration as a mechanism for resolving disputes within the Nigerian landscape. This has made Nigeria, it has shaped the significant trends of the Nigerian arbitration landscape. So the recent legislative reform, which is very key to us, in 2023, the arbitration or the ADR community in Nigeria rejoiced over the significant turnaround of the arbitration landscape. The Arbitration and Mediation Act 2023 was reenacted to go to the next. Yes, can I have the next slide, please? Yes. So the Arbitration and Mediation Act of 2023 became the most transformative development in the Nigerian arbitration landscape. It repealed the decade-used Arbitration and Conciliation Act of 1988, which was long overused and overdue for reenactment as at that time. And the key innovations that that act actually outlined to make Nigeria a hub of arbitration and put it on global landscape in terms of arbitration is the fact that the act now aligns with the UNCITRAL model law of 2006, which reinforces Nigeria's credibility as a modern arbitration jurisdiction. Also, the recognition of third-party funding, which has previously not been the case, was made prominent by that 2023 Act. The provision for emergency arbitration, which enabled parties to obtain urgent relief before the constitution of a tribunal, is also a significant transformation in terms of the arbitration landscape in Nigeria. The Act also make clearer framework for arbitration-related court intervention, which is also key, as I have heard Mr. Shakumar mention. The role of court is so essential in terms of promoting arbitration and a country's opportunity to be seen as a global hub for arbitration. And there is also the surge of domestic and regional arbitration center, such as our own dispute resolution center, which was inaugurated in 2017 as a major player in the commercial dispute resolution landscape within the country and also outside of the country. There is the Lagos Court of Arbitration is also a significant institution that promotes the use of arbitration. The Lagos and the Abuja multi-door courthouses, most states within Nigeria have adopted the use of multi-door courthouses in promoting ADR and arbitration in particular The Regional Center for International Arbitration is also a significant, I think it's one of the three most prominent regional arbitration centers within Africa. And Nigeria have since seated the Regional Center for International Arbitration, which is a center that is recognized and also promoted by the Nigerian government. Arbitration, sectoral arbitration also have gained traction. You could move to the next slide, which is also talking about emerging trends and development within the Nigerian arbitration landscape. We have seen sectoral arbitration practice, like I have mentioned, the oil and gas industry, the construction industry arbitration, telecommunications, and the banking sector, which has had the NDIC inaugurate its own ADR unit. And to talk about, yes, please move to 2 slides away from here. Yes. So Nigerian courts, like I said, have played a significant role in shaping arbitration jurisprudence particularly through the support that it had given arbitration in Nigeria, enforcing both arbitration agreements and also the enforcement of arbitration awards. And a notable feature of this journey is the increasingly supportive stance of the courts in Nigeria. Several court decisions have affirmed the sanctity of arbitration agreements and the finality of the arbitration awards, and have helped in enforcing and promoting arbitration as a viable means of dispute resolution. And the case of Kano State's Urban Development Board versus Van Construction is a significant case in the arbitration landscape of Nigeria. That case has the Nigerian courts observed that disputes or differences which the parties to an arbitration agreement agree to refer to arbitration must consist of justiciable issues that can be tried through civil law, and that in cases like criminal cases, of course, cannot be offenses, or offenses cannot be subject matter of any arbitration and tribunal. This is to emphasize the public policy use of arbitration within the country. And we have cases like the Nigerian National Petroleum Corporation, NNPC, versus Fongtai Engineering Co. Limited. This is a landmark decision in Nigeria, which has the Nigerian Supreme Court reinforced the country's pro-arbitration stance. And it also underscores the finality of arbitration awards. And in that case, the dispute arose between the parties. And in the agreement of the parties, there was a recognition of arbitration as the mechanism for resolving dispute within the country. And in that case, it resulted to an award, in favor of the respondent company, which is for about $17 million and about over 22 million naira. And the NNPC initially offered to settle for a lesser amount, which the company initially accepted, but later retracted, insisting on full payment. And the company later sought to enforce the award in the Federal High Court of Nigeria. Initially, the NNPC, which is the organization against which that award was given, sought to set aside that award. But the Supreme Court upheld the award, and the decision underscores that Nigeria is actually been very supportive of arbitration, whether it involves states, individuals, or companies. And although that judgment was under the Arbitration and Conciliation Act, which is now being repealed, but it is important to note that regardless of the case, that arbitration and that the decision from that case still stands as it is here in Nigeria. Move to the next slide. Yeah, so another significant case is also this Start Oil Nigeria Limited versus NNPC, where the court was very instructive as it evidences whether courts are supposed to intervene or render more assistance to arbitration. And I think in that case, the courts reinforced the fact that the principle of arbitration must be upheld, and that the court emphasized that the enforcement of awards, even against state entities. It is important to note that there are several of such kind of cases within the Nigerian judiciary that have supported arbitration. And these decisions illustrate a gradual but definite evolution towards judicial deference to arbitration. It establishes the important principles that are critical factors in making Nigeria an arbitration-friendly jurisdiction and a hub within, not only in Africa, but globally. I have talked about the significance of the Arbitration and Mediation Act of 2023, which governs all domestic and international arbitration seated both in Nigeria and outside Nigeria. And to also note that Nigeria is a signatory to the New York Convention, and Nigeria have also signed various bilateral investment treaties which provide for investor-state arbitration. The growth of arbitration institutions, like for both public and private in the country, like I've mentioned, the GSADRT is one of such arbitration institutions, re-emphasize the fact that arbitration is being recognized in Nigeria and is being taken seriously, and Nigeria is doing a lot in that field to see that Nigeria becomes a global hub for arbitration. And inventions like this, recently the Federal Ministry of Justice in Nigeria also issued a policy, a national policy on ADR and arbitration. And that policy is to emphasize the use of arbitration and to create a standard. You know, Nigeria recently was involved in so many international arbitration, and significantly, the Nigerian case against the PNID is instrumental to the positioning of the national ADR policy, because it is important for Nigeria to place itself and to also create a standard within which all arbitration institutions can perform the functions of arbitration. You can go to the next slide. Yes, I've talked about the development in the institutional landscape of legal framework of Nigeria. The regional center, like I have mentioned earlier, is one of the oldest ancestral regional centers in Africa. We have the Lagos Court of Arbitration, which offers state-of-the-art hearing facilities and a user-friendly set of procedural rules. And the Nigerian Chambers of Commerce Dispute Resolution Center, with its comprehensive arbitration rules that encourage expedited proceedings for businesses within 90 days, is also significant in terms of the institutional landscape of arbitration in Nigeria. And the Chartered Institute of Arbitrators UK, the Nigerian branch, which is also a leading capacity building and training hub for advocacy in arbitration within Nigeria have gained significant milestone. I have become, I was trained under this institution to become a fellow, which is, and I know a lot of Nigerian lawyers and arbitration practitioners have been trained through this means to, in terms of promoting advocacy in the arbitration hub. And the Arbitration and Mediation Act, I mentioned the arbitration policy, which is also a significant transformation in terms of arbitration used in Nigeria. I've spoken about the notable arbitration cases. There are lots of, so many arbitration cases that you could find that have the Nigerian judiciaries in supportive of arbitration and promote arbitration practice within the Nigerian landscape. We also just mentioned that despite all this significant progress that we have made in Nigeria, Nigeria still grapples with a lot of issues, which is the last leg of my presentation. You could move to the next. You can move to the next slide. Yes, I've spoken about this, which is that the Arbitration and Mediation Act of 2023 have sort of standardized the issue of party autonomy, which is in any case the most important part of arbitration as a private means of mechanism of dispute resolution. It provides for a lot of default provisions that reduce ambiguity and judicial recourse. So this is to see the judiciary play a supportive role rather than interference with the arbitration proceeding. And that act has also encouraged the use of mediation, which is the first time Nigeria is having a codified rule to support mediation within the ADR landscape in Nigeria. The government of Nigeria recently introduced the policy on ADR, which I have mentioned, and that's legal and institutional framework positions Nigeria to compete with emerging arbitration hubs globally. So significantly, Nigeria's institutional and legal framework, I think, have done well in terms of placing arbitration as a significant mechanism for dispute resolution globally. Just to state that despite all this progress that we have made, there are some issues, and just like Mr. Sharukumar have mentioned for India, it is also the issue here in Nigeria, the fact that for institutional arbitration, there is need for the legislation to also emphasize the use of institutional arbitration. That way, other emerging ADR centers like ours will be put into a significant use as it should be. We have a lot of other institutions, but for us under the Chamber of Commerce, it's the opportunity for businesses and small-scale industry businesses to use this arbitration center. It's also important because the center actually came out of need for SMEs and small-scale businesses, which are the major part of the Chambers of Commerce. And the fact that for ad hoc arbitration, it might be too expensive for businesses that are just starting up to use the ad hoc arbitration proceedings. So so institutions like the GSADRT becomes very significant as it's lessen the burden with a very the charges are a bit low for businesses to be able to to take advantage. So it's not costly. It's significantly low, and it's important for such kind of institutions to be promoted so that other businesses that cannot afford the service of bigger uh, institutions can also take advantage of these institutions. Go down to the next. Yes, okay, so to talk about the current challenges, the fact that there is mostly enforcement delays in terms of both foreign and domestic arbitral awards. Sometimes it takes too long to 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 get these awards enforced in courts. And I think there was recently in 2021, a law firm carried out a review of how much time it takes to enforce this kind of awards. And I think between the High Court to the Supreme Court, it will take about 8 to 10 years, which is, I think, the most issue with judicial enforcement of the awards. And to also say that one of the difficulties that we find, which is also the problem that we must address, is the fact that while improving, the judiciary sometimes can overreach arbitration proceedings. There are occasional instances where courts intervene prematurely or even unnecessarily in arbitration matters. And the fact that there is limited understanding of the use of arbitration in the SME cycle. A lot of companies or organizations have not understood the significant value that arbitration brings to their businesses. The fact that despite the capacity that have been built in a lot of organizations, there is a greater need for awareness and technical capacity, even among lawyers, among judges, among institutions on complex arbitration issues, especially international investment law. And the fact that there could sometimes be political or bureaucratic resistance in terms of government agencies being reluctant to comply with awards, citing either public interest concerns and also the perception issues of cases like the P&ID case in Nigeria that have created reputational challenges for Nigeria. Although the Nigerian success in setting aside that award shows a commitment to due process in the Nigerian arbitration landscape. So I would say that Nigeria stands at a very transformative point in its arbitration journey, armed with modern legal framework like the Arbitration and Mediation Act, the Arbitration and ADR policy. Yet challenges will remain, especially in terms of enforcement and perception. So as arbitration stakeholders from Global South, I think that our collective focus should be on strengthening domestic institutions, especially like the NCCDRC, enhancing cross-border collaboration, which is one of the things that this tribunal is doing today, and the fact that ensuring that arbitration serves the ends of justice and economic development. So advocacy will have to continue in terms of what we're talking about. I think I'll just stop here before my time goes off. Thank you very much.
Thank you, Hauwa. It was a very interesting input from the West African nation, and the way the new Arbitration and Mediation Act 2023 has come into force and how it's going to function. One interesting thing analyzing this development, or particularly when it comes to as a policy implementation and review,
Yes.
the provision in para 19 in the policy which establish a 5-year implementation timeline along
Yes.
with requirement for review to align with the existing trends of arbitration and ADR. I feel it is quite a proactive aspect of the policy. What is your thought
Yes.
on it?
Yes. It is a proactive, like you have rightly mentioned, it is a proactive development in terms of making sure that arbitration is used significantly. And I think this is where all the other arbitration centers and arbitration institutions now will have to take advantage of that section and make sure that in terms of implementation, it is strictly implemented. For us at this center, what we are doing now is to make sure that in fact we plan to have a roundtable in the first week of June. The roundtable is for arbitration centers within the country or within this Abuja that we are, to come together and see how we could come up with strategies for implementation of the policy. So it's one of the things that we're looking at. What are the strategies that we could put in place to make sure that every section of the policy is being implemented as it should be implemented? Because quite apart from having good laws, implementation is also a key part of having the laws, which is one of the things that we as institution must be doing.
Thank you, Hauwa. And we are very, very happy to hear you. It's a wonderful presentation. And your continuous support for the Global South ADR is particularly expected, and hope it's already done. And we'll take it forward in the right path so that in the next edition, we'll be in a constructive role within this 2 years or 3 years of the implementation of the policy. Thank you.
Thank you for having me, and thank you for the opportunity to contribute to this.